Good morning, and welcome to the second case on our July 2020 docket before the Kansas Court of Appeals. Again, my name is Sarah Warner, and I am the presiding judge today. Before I call this case, I'd like to introduce to the attorneys our panel of judges. So with us is Judge Amy Klein, who came from Wichita and has served on the Kansas Court of Appeals this year, and then Judge Richard Walker has served as a senior judge on our court since 2015 and previously was a district judge in Newton. In preparation for today's argument, we have thoroughly reviewed the parties' briefs and the court record, along with a legal memorandum prepared by a research attorney. So this means that we're familiar with the facts, but of course, because this argument is being streamed online and being archived, I've asked appellant's attorney to provide a 1 minute or so summary of the case to provide some context as to what this is about and the issues that we're going to be discussing before diving into argument. This case is scheduled for 15 minutes of argument from both sides. I'll be keeping time, including any rebuttal time that has been granted to the appellant. So with that, I'm going to go on ahead and call the second case on this morning's docket, case number 122710 from Johnson County, Gary Mathews, appellant versus the City of Mission Hills, Kansas Board of Zoning Appeals appellee. Would the parties please state their appearances?
Patrick Hughes for the appellant Gary Mathews.
George Sheldon for the appellee City of Mission Hills.
Mr. Hughes, would you like to reserve any time for rebuttal?
I'd like to reserve 3 minutes, please.
3 minutes are granted, and counsel, you may begin your argument.
Thank you, Your Honor. May it please the court, this is a dispute between the appellant Gary Mathews and the City of Mission Hills concerning the issuance of a building permit by the City of Mission Hills. The City of Mission Hills was conceived as an elite garden community by J.C. Nichols. It's marked by fountains and statues and sculptures and urns. It has water garden, it has winding streams and wooden hills. And this character is not accidental. It's the result of the City of Mission Hills' tight regulatory controls. That's why people who live in the area purchase homes in the area. And this case concerns the Architectural Review Board's failure to follow the requirements of those tight controls when it issued to the Kansas City Country Club a building permit for a large industrial outdoor golf course fan near the patios and porches of the adjoining property owners, specifically Gary Mathews. This decision should be reversed because the ARB, the Architectural Review Board, did not act lawfully or reasonably. The ARB didn't comply with the mandatory procedures set out in the city's governing code designed to ensure the integrity of the decision-making process. And this happened because there was not substantial competent evidence to support a finding that the ARB needed to make in order to approve the building permit. The proposal would not adversely affect the values of surrounding properties. The City of Mission Hills local law requires two things that matter here. First, as a precondition to a decision about issuing a building permit, the applicant has to meet a high standard. It must show, and the ARB must make a finding that the proposed structure will not adversely affect the values of surrounding properties. The City of Mission Hills chose this zero tolerance standard in advance of the passions that give rise to the current dispute to protect the values of the community. It's a high standard, but it's not an impossible one. And second, the City of Mission Hills also sets an elevated standard for assuring that the findings are made with care, consideration, and importantly, reviewability. It mandates that all matters requiring decision by the ARB be decided by a motion. But the ARB didn't properly meet either of these requirements. The minutes state vaguely—
Counsel, I'm going to talk a little bit about that motion requirement.
Yeah.
What kind of level of specificity are we talking about in requiring a motion? Or does it need to be for every individual finding that the board makes, or is it just like to have a motion to approve this building permit?
It needs to be a motion on the decision. And here the minutes tell us that there was an agreement by the ARB about the satisfaction of the conditions, independent of the motion, because it tells us that this agreement happened before the motion was made. The motion that was made didn't refer at all to anything about the conditions being satisfied. Instead, the motion was limited to imposing limitations on the fan that would be approved. So the specificity isn't set out in the zoning code. But what we know in this case is that there was only one motion, and that motion did not refer to the conditions that needed to be satisfied, the preconditions. It assumed they had been met.
Well, how do you get around the fact that opposing counsel, who's here today, was apparently at the meeting and said, here are the 5 factors. If you can't find all 5 of these, vote no on approving this project. And that's in the minutes. Does that have no consequence whatsoever?
No, it may have consequence, but it doesn't matter to the question of whether the board acted in accordance with the rules that the Mission Hill set out. It's true that they were given advice, they were given conflicting advice. They were giving advice by council. They were also given advice by the city administrator that told them that in order to reach a different decision in this case than they'd reached in other cases, they needed to find something was different in this case. Well, that's not necessarily true. We don't know what happened in the other cases. In this case was to be decided on its own merits. And we have to ask the question of, on what basis did the ARB decide that the country club had met its burden to show zero impact on property values? And in the absence of a motion, and given the record in front of us, which lacks any evidence that the effect on values on surrounding properties is anything but adverse, we have to guess. We're left in a quandary. And if we have to guess, the city hasn't provided an adequate record for review. But beyond that, in this case, we know that the ARB could not have followed the law, could not have acted reasonably in approving the building permit because there was no substantial competent evidence from which to find that an industrial golf course fan on the 12th green would not adversely affect the values of surrounding properties.
The council, wasn't there evidence provided on both sides of that issue?
No.
And the board had the ability to weigh the evidence from Mr. Shaner and decided that it wasn't credible and place more credibility on the evidence that was the testimony that was provided that it wouldn't impact the surrounding properties, particularly because the temporary fan was so much louder than the permanent fan that they were intending to install?
No, that's not the case here, because there was certainly evidence. There's significant evidence that there would be an adverse effect on property values, but there wasn't evidence on the other side of the question. The evidence was the testimony of 8 surrounding property owners who addressed directly this issue of the decline in their property values. 6 people who lived near other golf course fans and talked about the negative impact on their property values. And the opinion of Bernie Shaner, a well-known appraiser who advised that noise like that from golf course fans could impact property values. This was all evidence against the country club, and it couldn't assist it to meet its burden of proof. The country club presented evidence focusing on the benefit of having a fan, but not addressing the impact the fan would have on surrounding properties. But there are 4 categories of evidence that the city is arguing go to that question on their side, and they really don't. Let's look at them. The first one is the city says that golf course fans don't violate the public offense code. Well, the fact that the noise from a golf course fan isn't criminalized does not mean that there's no impact on property values. The argument presupposes that the standard for excessive noise in the public offense code is designed around the same principle as the zoning code, the precondition of zero negative impact on surrounding properties. Nothing before the court supports that premise. More importantly, we know there's no relationship between whether golf course equipment adversely affects property values and whether it violates the public offense code, because golf course equipment is generally exempt from the noise limits. It doesn't matter how loud it is, it still does not violate the public offense code. The city also points out that the ARB had made personal observations of an electric fan on the 9th green and a gas fan on the 18th green. But the question before the ARB was the relationship between a golf course fan noise and value, where the undisputed evidence is that the fan is noisy. Listening to similar noise at its source doesn't answer the question of how the noise affects property value. It just tells the ARB.
So was there any evidence submitted or discussed even regarding the effect of these previous electric fans that had been installed on the golf course and on other golf courses on the surrounding property values?
Yes, there were 6 people who came in to testify about this from other who had fans near their properties about how it had negatively impacted their property values. There was one man, Mr.
Oh, I'm sorry. Please continue.
There's one additional man, Mr. Wallback, who came in to testify that at his property, he couldn't hear the fan when he was inside of his house. It didn't bother him, and that at his property, there were other noises in the environment that were louder than the fan that was on the green that was close to his house.
And is it your position that that is the sole evidence in the record on the issue of property value?
It is the sole evidence on that addresses the question of the impact of noise on property value, other than the testimony of the people who are affected here on the 12th green and the testimony of Bernie Shaner. But there was testimony that from the country club that they had a fan that was near the dining area and that nobody had complained to them about noise from the fan at the dining area. But they also said that they had complaints from other people about the noise of electric fans. So the evidence about people who eat at the country club not being sufficiently offended by it to complain doesn't have any bearing on the question of whether those same people would complain if it were next to their patios.
Doesn't that, I mean, that's a weighing and a credibility determination on the part of the board, correct?
It's really not, because what we're talking about here is an absence of evidence, right? We're saying nobody complained. Well, what does that mean? Nobody complained is not evidence that you've met your burden of proof to show there's no negative impact. It's only evidence that you don't remember that anybody complained at your restaurant, but you do remember that people have complained otherwise than at your restaurant about the noise that's created by the fans. So
and
it's
those are
not
certainly
evidence.
arguments that could have been made and probably were made to the board, correct?
Pardon me?
Those were arguments that were made to the board in consideration of this issue, right?
I don't know that anybody made the argument to the board that the absence of evidence is not evidence of absence. I don't know that that's contained there. What people were doing was presenting the evidence to the board. The country club was presenting evidence about why they wanted the fan, and the opponents were presenting evidence about the real question here of what's the impact on property value. And the country club didn't address that issue on property value, but the district court and the city argued, well, there's an absence of any of certain types of evidence that somebody might have presented if they wanted to prove that there was a negative impact, which reverses the burden of proof. The burden of proof was not on the opponents, who didn't have subpoena power, to draw in still more than 6 people to testify about what the negative impacts had been elsewhere. The burden was on the country club to establish what is admittedly a high burden that the city of Mission Hills has decided is the appropriate burden for this question, which is to show zero impact on value.
Let me ask you two things that really puzzle me about this case. Number one is, if we find in your favor and reverse this and say, no, you can't have this electric fan out there, they can put temporary fans out there with generators even noisier than these electric fans would be, which presumably puts your clients in a worse position than they are with this decision. Second thing that puzzles me is your appeal of the special conditions that put on there, because if we find that yes, they could grant this building permit, but no, they couldn't put the conditions on, then you're in a worse position than if you hadn't appealed at all, because then they can run them 24 hours a day, 7 days a week anyway. So I guess I'm really puzzled about those aspects of this appeal.
there are answers to both of those puzzles. As to the, I'm sorry, I've slipped my mind, the first one to begin with.
Well, if we say you're right, they couldn't do it, they'll just put temporary fans out there, run them 24 hours a day, and
Sure.
even noisier than what they wanted to put in.
Right, and the answer to that is that's what the country club tried to do here on the 12th green. Is they first applied for an electric fan, and then when there was opposition, they pulled that and put on a gas ban, which resulted then in a lawsuit, a nuisance lawsuit. And so then that nuisance lawsuit was essentially mooted by an application for an electric fan. So we can't compare an electric fan to a gas fan because it is not clear that they have a right to have a gas fan. That gas fan may be a nuisance that can be enjoined. There was litigation over that.
Yeah. Is that still pending, or is that dismissed?
That was dismissed as part of, in connection with all
I
of this.
assume without prejudice could be refiled, I assume.
So I wasn't involved in that litigation. I'm not sure what the terms of the dismissal, but that was dismissed in connection with this.
You want to comment on my second puzzle then?
Sure. The second question was, well, what about the fact that if we reverse what they did by saying they couldn't impose conditions, then there are going to be no limitations? Two thoughts about that. One is that if they couldn't impose limitations, that's exactly what they did. So what you'd be doing is reversing the decision, and they would have to go back and make a determination about whether or not to approve the fan without there being any limitations. Now, if they're faced with that question, are they going to answer it differently? Well, perhaps so, because clearly they felt that there was an adverse impact that merited limiting what it was that when the fans could operate, and therefore it seems likely that you can't find that there's zero impact on value if you have to say, well, okay, but they can run at any time. And so the condition itself is what it is, the decision that was to say you were approving it with conditions that would be reversed.
Thank you. I didn't address my questions.
Pardon me?
You've addressed my questions. Thank you.
Okay, thank you.
Council, we're at the end of your time. Before we start eating into your rebuttal time, but if there are other questions from the panel.
No.
All right. Thank you, Council.
Thank you.
Your honors, may I begin?
Yes, please.
So I think everyone's identified really the key issues in this case, and just to take a step back, I'd remind everyone that the ARB had 4 different hearings on this issue, 4 different hearings. The ARB members went to the golf course. They listened to the fans in person. There was as Mr. Hughes mentioned, that there were complaints raised in these hearings about other golf course fans, and then Mr. Mathews and others said that because of the topography of the 12th green, which is where the fan at issue would be placed, that there would be an amplifier effect because it's the Mr. Mathews' home is above the 12th green, and so there was a contention that there would be an amplifier effect. The city hired an acoustical expert to come in and investigate that claim, and that expert determined that there was no amplifying effect by a fan on the 12th green. The country club has fans on its 9th and 18th greens, which Mr. Hughes mentioned are near 2 patios. It's also near their clubhouse. It's also near their pool. I think it's entirely relevant that they have not had complaints about the use of those fans. And I would point out that this is not a situation where the country club asked for something to be placed in a position where any negative impact wouldn't be felt by them. It would only be felt by others. That the country club is placing these fans right in the middle of their clubhouse and pool and patios. And so I think that's relevant as well. And then as we've discussed briefly, there was testimony from some homeowners that the other golf course fans did not have any impact on their use and enjoyment of their properties. And so the ARB is faced a lot of evidence going both ways. And so they had to make a decision. And their decision was to approve the building permit with certain use restrictions that address many of Mr. Mathews and the other homeowners who opposed the building permits applications concerns. And given that volume of evidence that they heard and the city's ultimate decision, I would respectfully submit that that's almost a per se reasonable decision. And under the law, of course, neither Judge Mason nor this court is entitled to substitute their judgment for that of the city. And so we think it's pretty clear that Judge Mason's decision should be affirmed, and that the city's decision to approve the permit application was reasonable.
Council, is the fact that this decision came from an architectural review board, does that place any inherent limitations on the kind of conditions that can be superimposed onto a building permit?
No, it did not. And this isn't just a bit of background. This had to go before the architectural review board because the permit asked for an electrical outlet to be permanently installed on the course, and that's why it had to go to the ARB. But no, the city's municipal code actually states that that the ARB may attach such requirements and conditions as it deems appropriate under the circumstances. And then it says, including but not limited to, and then it lists a number of potential requirements and conditions. And then the code goes on to say, and I'm just reading from it, and this is in the record, it's volume 5, page 66. In addition to the foregoing powers, the ARB shall also have such other powers as have been delegated to the ARB under these zoning regulations, and shall have such additional powers as are necessary to ensure that the ARB's responsibilities are fulfilled. And so I think that the municipal code is quite clear that the ARB has the ability to impose the conditions that it did in this case.
Council, one more question, and,
Sure.
and that is, I think that you addressed this a little bit in your opening remarks, but aside from the homeowners who were opposed to the installation of the fan, and then the real estate appraiser who was hired by Mr. Mathews, what evidence could you just kind of itemize the evidence on the other side that the city considered, that the zoning authority considered, to determine that there wasn't any adverse impact on property value here?
Sure. And from my perspective, there's almost two steps to that. If you're talking about adverse impact on property value, first of all, there has to be some sort of impact on the property, right? Before the value can be adversely impacted. And so when we're talking about the evidence that would support the city's determination, I mean, we've talked about how the ARB went out and listened to these fans, and I was there. I mean, we were all just standing around the green, so we're within 5, 10, 15 feet of the fans while we're doing this. But the ARB members personally observed these fans, and so they were able to make a personal decision on what sort of or the level of noise and what sort of impact it would have on surrounding homes. And so to me, that on some level, this is somewhat subjective. What level of noise would impact somebody's use of their property, and the answer for one person may not be the same for another person. And so I think it's really key that the ARB was able to listen to these types of fans and then use their personal knowledge to make a decision. And of course, you marry that with the fact that they brought in the acoustical expert that said there was no amplifying effect from the 12th green. And so it was entirely proper for them to focus on their own personal experience and listening to these fans on the 9th and 18th greens. We've talked about how the country club has these fans in the middle of its, or not in the middle, but near its clubhouse, near its outdoor patios, near its pool, and that has not been a problem for them. They haven't had any complaints. We've talked about Mr. Walbach in particular testified that he hasn't had any adverse impact from the fan near his house. The one thing that we haven't talked about is in considering whether this fan would have an adverse effect on surrounding property values. We've only talked about the noise, right? But the club came in and said, well, one of the benefits to the club is it improves the quality of the green, and you don't have a dead green and things of that nature. Well, that's also a value to surrounding property owners to have. Obviously, one of the benefits of living on a golf course is to have a beautiful, well landscaped golf course property right next to you. So there's a benefit to the surrounding homeowners to the extent that the country club frankly does anything to keep up the quality of the golf course as well. You guys have already mentioned that the club can run louder gas fans if the electrical fans were not allowed, and so that would certainly be detrimental to other property owners.
Counsel, I have a question. I won't mention the inherent danger of golf balls going through windows. So this may be a disadvantage, but would you address the issue? What I see is one of the biggest areas of complaint that your opposing counsel is making is a procedural one, that the ARB didn't go point by point and say, we make these specific findings, so moved. Kind of did it by catch-all reference. Address whether that is up to code.
Absolutely, Your Honor. So what the Mission Hill City Code says is all matters requiring a decision of the ARB shall be determined upon a motion by a member. And in this case, the decision that the ARB was faced with is whether to approve the building permit application or not. And it's undisputed that decision was made by a motion. Now, what Mr. Mathews is arguing is, well, there were 5 different findings that had to be met in reaching that decision, but I think that's important. These were findings that had to be met to reach the decision. The decision ultimately is whether to approve the building permit application or not. And what we have in the record is, and I have personal knowledge of this because I was there. And this is all in the minutes. The ARB was specifically instructed that each of the 5 findings in section 5-146 must be met to approve the building permit application. I read each of the findings to the ARB members, and the ARB meeting minutes state the ARB agreed that the findings had been met. And so, frankly, that's much more than a lot of cities do. And I think you need to take a step back, big picture. The ARB is deciding various things at each meeting. Yes, the final decision has to be by motion, but there is no requirement. In fact, the Evan case says you don't have to have written specific findings of fact, and that's almost what Mr. Mathews is asking for. And to me, it's really a form over substance. I'm not sure what the difference is by requiring the city to say, okay, well, let's have a motion as to finding 1 under section 546, all in favor, aye, as opposed to just saying you can't in order to approve this, you have to find all 5 are met, and the ARB said yes, all 5 are met. And frankly, there's just nothing in the city's municipal code that would require each of the findings in section 145 to be made by motion. And I would respectfully submit that this court shouldn't impose additional procedural requirements on the city that are outside of the city's municipal code and not required by Kansas law.
Thank you. Address any question?
Counsel, you have about 2 minutes, I think, left of your argument time, just to let you know.
Thank you. And I think I've addressed most everything. And so unless your honors have any additional questions, I'll just wrap up real quick.
Are there any other questions from the panel? I see no questions, counsel.
As I started out, this is a situation where the city had 4 different hearings, went out of their way to go to the property, listen to the fans, went out of their way to hire an acoustical expert to investigate the possibility that there was an amplifying effect due to the topography of the 12th green. And so I think it's clear that this is not something that the city rubber stamped. This is not something that the city misapplied the burden of proof, that it considered all evidence, fully considered all evidence, and made a decision that it felt was compelled under the rules and based on the facts presented. And the fact that the city imposed some use restrictions to really specifically address the main concerns addressed by Mr. Mathews and other homeowners just really shows the reasonableness of their decision. If the homeowners were concerned about the fan running at night, or the fan being run in non-business hours, or things of that nature, and that was the genesis of their concern that their property values would be impacted. Well, the city addressed those. I mean, basically the city kind of put those aside and said, well, we're going to put use restrictions on this fan, and so that's not going to be a problem. And so I think the evidence would support a finding, even absent the conditions, that there's no adverse impact on surrounding properties. But then when you add on the use restrictions, then I'm not even sure there's a basis to argue that there's any argument that there even should be or could be a finding of adverse impact on surrounding properties. So I would respectfully request that Judge Mason's decision that the city's approval of the permit application was reasonable, and that Judge Mason's decision should be affirmed.
Thank you. Mr. Hughes, you have 3 minutes for your rebuttal.
Thank you, Your Honor. The courts are used to dealing with questions of the value of property within the context of disputes. And the law is fairly clear that the fact finder doesn't have the ability to merely look at evidence about property and reach a conclusion as to value. That instead, when the party with the burden of proof needs to present evidence of value, and in the absence of there being evidence of value, then the burden of proof is not met. What we have here is an argument that things are inherently subjective, which is exactly why evidence with respect to the impact on the value of property is important. And the city of Mission Hills did not need to create the standard that it created, but it created that standard because it wanted to provide assurances to property owners. And that standard requires not that the opponent come in and prove anything, but that the proponent come in and prove that there's either going to be the same value for adjoining properties after, if the proposal is granted, or that the values are going to increase. And in the absence of that evidence, the city of Mission Hills has said there is no power to grant a building permit. Here, we have no evidence on property value other than evidence that goes against the burden of proof that the country club had. And so it may be that in some other municipality, there would be an appropriate weighing and balancing of interests, but that's not the rules that the city of Mission Hills adopted, that people have relied on. They instead decided that it was necessary to have a finding that there be no adverse impact on property values before the ARB would have authority to be able to approve a building permit. And this appeal really focuses around the central point that justice then requires that the city of Mission Hills ARB render a decision in a way that allows for meaningful judicial review of its compliance with that law. The ARB owes the court and the parties in front of it a record that establishes that it operated properly. Otherwise, the right to appeal is empty. It has here, then it has to show that there is sufficient evidence on the impact on property values. It's plain that there is an impact on the properties because there's lots of testimony. There's no testimony that you can't hear the fan. The only testimony that there is that there's impact on property. The question is, what does that do in terms of translating into value of those properties? And on that, the only evidence is that it's a negative impact. And so there cannot be, in this circumstance, an approval of the request. And so we ask that the decision of the ARB be reversed because it's not supported by substantial competent evidence, and they did not make and could not make the finding that they were required to make to have the power to approve this building permit. Now, the arguments that has been made, well, there's no longer any impact once these conditions are imposed, but that's speculation. We have people who are perhaps working on weekends or home at weekends when this can be operated. We have people who might be working from home. In fact, I think we had somebody who testified to that effect. We have people who may be retired. So the fact that their operating hours does not prove there's zero impact. It just may reduce the nature of that impact. Thank you.
Thank you, counsel. I want to thank both of you for your arguments today, as well as your briefing in this matter. We will take the case under advisement and get an opinion out as soon as we are able. And the court will now